seriously popular.
Welcome to the Trial Podcast, The Inquiry. I'm Caroline Cheetham.
And I'm Liz Hull.
We'll be back in a second.
This episode is brought to you by Shopify. Upgrade your business with Shopify, home of the #1 checkout on the planet. Shop Pay boosts conversions up to 50%, meaning fewer carts going abandoned and more sales going cha-ching. So if you're into growing your business, get a commerce platform that's ready to sell wherever your customers are. Visit shopify.com to upgrade your selling today.
I make it absolutely clear that it's not for me as chair of this public
The decision to move Letby to day shifts raises serious questions which we will be investigating. Was there a cover-up? If so, why?
I would pray for God to save her. He did. He saved
The
her.
convictions stand.
But the devil found her.
In August 2023, a neonatal nurse called Lucy Letby was convicted of killing and harming 13 babies in her care. She was sentenced to 14 life terms and declared one of the country's most prolific serial killers. A year later, she was convicted of attempting to kill another baby and given another life sentence.
All this happened in the Countess of Chester Hospital over the course of a year from 2015 to 2016. But what went wrong? Who knew what and when? How was a nurse able to kill and hurt babies on a ward under the noses of her colleagues?
The Thirlwall inquiry is now underway in Liverpool and will attempt to answer these questions and more. We'll be there covering events every day. Hi, so we're back after a few weeks' break over Christmas. The inquiry's been back sitting at Liverpool Town Hall all this week, and actually we're reaching the final stages now with only a few more days of evidence left to hear. Today we're bringing you the evidence of MP Jeremy Hunt, who was the Health Secretary at the time when Lucy Letby was working at the Countess of Chester Hospital.
He told the inquiry that Lucy Letby's crimes were appalling and that he took ultimate responsibility for what happened on his watch.
He also said that what happened at the Countess of Chester was the dots were not joined up, and he accepted that delays in implementing recommendations from previous inquiries, such as having medical examiners, meant Lucy Letby was not stopped sooner.
He called for the NHS to have a more transparent process to identify when genuine mistakes are made so that malign actors like Harold Shipman and Lucy Letby are spotted sooner.
We're also going to talk later on in the podcast about something that happened before Christmas when Lucy Letby's new legal team told a press conference there was new evidence casting doubt on her guilt for the Court of Appeal to consider.
Welcome to episode 19, Jeremy Hunt.
So, as we said, the inquiry team's had a couple of weeks off and we're really now into the final few days of the evidence. And what's happening is the inquiry is now moving its focus from staff who worked at the Countess of Chester Hospital during this period to the wider NHS and what the health service can learn from what happened in Chester. Now, we're going to come to what Jeremy Hunt had to say quite shortly, but first we wanted to bring you the evidence of a man called Ken Gerald. Now, he's a former senior manager who retired last year after working for more than 50 years in the NHS. Now, over that time, we were told, he held various senior posts in hospitals and on their boards. And because of that experience, he was actually the man asked to draft the first code of conduct for NHS managers. That was back in 2002. And it was off the back of recommendations made by the inquiry into the Bristol heart scandal. Now, he said it was no accident that he made the care and the safety of patients the number one pledge, ahead, he said, of personal interest, reputation of the organisation or protecting colleagues when he drafted that code. And actually, Liz, he had a personal sort of incident involving his wife that he said helped to cement the importance of patient safety. And he shared that incident about his wife with the inquiry.
Yeah, so he told this story, which happened early on in his career, back in the 1980s, when he said he was approached by a surgeon at the hospital where he was working. Now, this surgeon had concerns about a colleague. He said the surgeon was worried because he'd learned Mr. Gerald's wife was undergoing treatment, and he wanted to warn him that she shouldn't be operated on by this particular man. So at that time, Mr. Gerald said it would have been impossible for a manager like himself to challenge a surgeon because they were held in, such high esteem. So instead, he decided to try and set up an inquiry into the service this surgeon ran as another way, really, to get to the bottom of the concerns. But he said he was treated with contempt and disdain by this surgeon when he suggested that his service should be examined.
And the surgeon who was the object of my attention replied to me, and I still have his note, to say that he wasn't going to respond to a letter from a snivelling clerk. And I almost let it go. I remember the moment of thinking, have I got the courage to challenge this?
So eventually he said he went back to the surgeon who initially had come to see him and asked him whether he could live with himself if he continued to ignore the concerns simply because they were too difficult to tackle. Now, he said what he did damaged his relationship with that surgeon and, in fact, all the other consultants at the hospital as well. But the bottom line was it worked. The problematic surgeon was confronted and ended up retiring soon afterwards. Now, Nicholas Delaporte, the barrister for the inquiry, asked him what he took away from that experience.
What then happened in the story that we've just been talking about absolutely imprinted on my heart and in my mind that patient safety has to be the first responsibility of everyone in the NHS, including the managers, and that we need to act, and that's the crucial word, we need to act to protect patients from harm.
But significantly, he said the code that he drafted in 2002 was never properly implemented in the NHS, nor was any manager, to his knowledge, investigated for a breach of it, which he said was actually a point of great sadness for him. And we know, don't we, that the government is currently consulting on how managers in the NHS can be regulated to make them more accountable. And the judge in this inquiry, Lady Justice Thirlwall, is also being asked to consider the issue as well.
So Mr. Gerald was also asked about current rules or guidelines the NHS managers are supposed to adhere to. Specifically, he was asked about a document called the Leadership Competency Framework, which was published by the Department of Health last February. Now, he said this framework is flawed because, like many other documents in the NHS, it's simply too wordy, too detailed, and too complicated. He said it didn't make clear enough that patient safety must come first, and it relied on managers carrying out self-assessments and undergoing appraisals, both of which, he said, had their limitations and were ultimately inadequate.
How much of this can people really take into their hearts and minds and do something about? That's the problem with a lot of this. If we're realistic about human nature, there is a very strong temptation in any organisation, if something goes wrong, for people to try and conceal what's happened, to protect colleagues, to protect the reputation of the organisation. And there needs, in order to counterbalance that, there needs to be a very specific, clearly worded commitment to something that is strong enough to stand some chance of counterbalancing it. And I don't see it here. The more complex and wordy you make it, you will lose people. So the simpler you can make it, the better.
He also said the NHS has a poor corporate memory. In other words, it isn't very good at learning from its mistakes. It's much better, he said, at writing reports and recommendations than actually implementing them or enacting change.
Yeah, and this is going to come up a bit later, actually, with Jeremy Hunt, who basically said very similar things in his evidence. But anyway, Mr. Gerald concluded his evidence by saying that he supported the idea of a new code of conduct for managers and even a common code for everyone working in the NHS as a whole to better protect patients. He also said that he supported the establishment of a disbarring list, effectively a sort of blacklist of managers who shouldn't be allowed or appointed into new roles if they're found to have made serious mistakes or presided over failures.
And he also said there should be a statutory duty of candour for individual managers and a similar duty to require them to act on patient safety concerns. But he said he didn't think a formal statutory management register, like the medical register for doctors, from which managers could potentially be struck off, would work. He said that this is because, unlike nursing or medicine, which has specific entry requirements or qualifications, management is an occupation, not a profession. Defining the entry standard would be complex, he said, and might exclude key clinicians such as senior nurses or doctors from ever holding management jobs.
So, as we said, quite late yesterday, the former Health Secretary Jeremy Hunt was called to give evidence. Now, he was in post from 2012 to 2018 when Lucy Letby was working. He started his evidence to the inquiry by apologising to the families of the babies killed and harmed, and he told them he took ultimate responsibility because what happened at the Countess of Chester Hospital happened on his watch.
I think it's probably appropriate that I should open my comments by saying to the families associated with this terrible tragedy that it happened on my watch as Health Secretary, and that although you don't bear direct personal responsibility for everything that happens in every ward in the NHS, you do have ultimate responsibility for the NHS, and insofar as lessons were not learned from previous inquiries that could have been, or the right systems were not in place that could have prevented this appalling tragedy, then I do bear ultimate responsibility, and I want to put on record my apology to the families for anything that didn't happen that could potentially have prevented such an appalling crime.
And that really became a bit of a theme of his evidence, that very, very few recommendations from previous inquiries have been implemented. Now, specifically, Mr. Hunt talked about the introduction of medical examiners, which he said was a recommendation first mooted after the inquiry into Harold Shipman's crimes back in 2004. But he admitted it wasn't until more than 20 years later when it was finally put in place. This is last year, because it was too costly and because there was a shortage of doctors in the NHS, and the priority was for them to treat patients instead. And he admitted to Rachel Langdale, the barrister for the inquiry, that if a medical examiner had been in place at the Countess, then Lucy Letby may have been caught sooner.
Do you see, looking back, the significance of that recommendation and how that may have made a difference in a case such as the one this inquiry is examining?
I think so. I think of all the things that could have potentially meant that what happened at the Countess of Chester was spotted earlier and the dots were joined up, would have been having medical examiners. I think that it is something that I look at as being one of the things that we took too long to implement.
Now, one of the responsibilities of a medical examiner is to talk to the bereaved families, and the inquiry's already heard that in at least one case, this is the case of the mother of baby E, she would likely have raised concerns about Lucy Letby's behaviour, which could have raised a red flag as early as August 2015, which was actually just 2 months into Lucy Letby attacking and killing babies at the hospital. Now, Mr. Hunt said he finally found the money for medical examiners to be introduced into the NHS in 2023, not when he was the Health Secretary, but in fact when he was the Chancellor.
So I wanted medical examiners to happen because I wanted the NHS to have a better learning culture and better processes in place to learn from medical error. But I recognise that there is a big read across to deliberate harm done by the Shipmans, the Letbys, whoever.
He also called for recommendations from inquiries to be prioritised using a traffic light system, he suggested, so that it was clear which ones were urgent safety measures and needed to be implemented within weeks to protect patients across the whole of the NHS. And he also said recommendations needed to be more specific. He said, for example, it was no good sending a round robin email to all staff about raising awareness of the possibility of malicious harm, because it would end up as a tick box exercise. He said they needed to be better translated so that they had an impact on the ground. He also said NHS managers were constantly being bombarded by recommendations from a range of organisations, and there was no clear system or body that monitored ones that were implemented and ones that weren't. He said this was a huge gap to fill. And he said frequent cabinet reshuffles were unhelpful because it meant recommendations were too often kicked into the long grass.
Finally, he did say the NHS was too target-driven. In fact, he called it target-mad. And he said this had created a blame culture where there was a lack of transparency in admitting genuine errors made by well-meaning doctors and nurses. And what this meant is it was harder to spot and root out the rare occasions when what he called malign actors like the Shipmans, the Allets and the Letbys were causing deliberate harm. And he said getting rid of some of those targets would mean the NHS would be more patient-focused. And in fact, he said he regretted not dismantling more of those targets when he was Health Secretary. We'll take a quick break there. So away from the inquiry, as we mentioned at the top of the podcast, before Christmas, Lucy Letby's new lawyer, Mark MacDonald, held a press conference where he said he would be asking the Court of Appeal to immediately review her convictions because he said the main expert witness in the trial had changed his evidence. Now, this is Dowie Evans, and a lot of focus has been on his evidence over the past few months. But what Mr. MacDonald said in this December press conference was that Dr. Evans had altered his view about how the babies had died. He said this related specifically to baby C, baby I, and baby P. And he said as a result of this, he would now be asking the Court of Appeal to look again at their original decision, and he called for them to reopen her case. Now, this is separate to any application to the Criminal Cases Review Commission, which we call the CCRC. We should say that we've asked Mr. MacDonald to come on to the podcast a few times. At the moment, he's declined our invitation, but he knows it stands. We'd love to have him on any time. So it does mean that we don't know the exact details of what this renewed application to the Court of Appeal will look like. But we wanted to find out a bit more about the legal process. And don't forget, the Court of Appeal has already dismissed Lucy Letby's appeal against her convictions twice. So asking them to re-look at their decision is really unusual. So we wanted to get the thoughts of Tim Owen, KC. Tim's an eminent defence barrister, and of course he has his own fantastic podcast called Double Jeopardy, The Law and Politics, with the former Director of Public Prosecutions, Ken Gerald. Liz and I are both avid listeners to that podcast, and they often discuss the cases that we're covering here on the trial. So, Tim, thank you for joining us again on the podcast. We've talked before about the sort of what now for Lucy Letby, if you like, and you had walked us through the options. And then, of course, Mark MacDonald held a press conference before Christmas and seemed to indicate certainly another route beyond or before the CCRC. So we wanted to get you on just to chat about whether you sort of witnessed that press conference and what you made of it, and then what the legal routes possibly are now for Lucy Letby, and is Mark MacDonald right that there is a different route than the CCRC?
Well, he is right that there is a different route. There is an exceptional jurisdiction, which I think is the one that he was obviously trying to highlight in that press conference. And it's just to get into the detail of it, because I think it is important to get this right. There are things called the criminal procedure rules, which are, as the title suggests, rules set out which cover all aspects of the criminal law procedure and the way the courts operate in criminal cases. And Rule 36.15 provides a power to reopen the determination of an appeal. And the rule applies, I'm reading from the rules, where a party wants the court to reopen a decision which determines an appeal or reference to which this part applies. And it says the application must specify the decision which the applicant wants the court to reopen and explain why it's necessary for the court to reopen that decision in order to avoid real injustice, you've also got to explain how the circumstances are exceptional and make it appropriate to reopen the decision, notwithstanding the rights and interests of other participants and the importance of finality, and then significantly, why there is no alternative effective remedy among any potentially available. So really the task that Lucy Letby's new legal representative faces, if he's going to go this route, he's got to show why it's necessary to avoid real injustice and why the CCRC is not an alternative effective remedy to Lucy Letby.
So I mean, what he said was that there was significant and profound evidence that her convictions were unsafe. So that's the key thing, is it? That this evidence has to be new?
Well, it doesn't have to be new. The rule doesn't specify any particular sort of limitation on what the circumstances might be which make it exceptional. What he was saying in the press conference is that the main prosecution witness has fundamentally changed his evidence, specifically in relation to the causation of 3 of the deaths. Now, if that's right, if that is true, that within a year of the Court of Appeal dismissing the application for leave to appeal, in other words, shutting off Miss Letby's appeal rights, if it's right that the Dr. Dewi Evans has changed his opinion, then frankly, that is exceptional. And I would expect, if that was the case, that the prosecution would themselves seek to relist the case, because it would mean that the prosecution have achieved, if you like, the dismissal of the appeal and the upholding of the convictions by presenting the main prosecution witness as reliable, because the issue on the appeal was that the trial judge was wrong to admit Dewi Evans's evidence, that he wasn't a reliable or credible witness. Now, we all know, I think, that within, 24 hours of the press conference, Dr. Evans has issued a statement saying that what Mark MacDonald had said.
No, I haven't changed my mind.
Yeah, so he said, no, that's not true. I haven't changed my mind. And Mark MacDonald in the press conference was claiming to have, that there exists a written statement from Dewi Evans withdrawing his evidence or changing his mind. Now, I don't think he produced that written statement at the press conference, and we'll have to see what emerges. But I think my understanding is that he is going down this route. It's, as I say, Criminal Procedure Rule 36.15, to not go to the CCRC. And the explanation, presumably, is that it isn't an effective remedy for Lucy Letby to have to wait possibly years for the CCRC to refer her case. And why should she wait if the prosecution's main witness has changed his mind?
And have you done that before, where the prosecution have said, as a prosecuting barrister, hang on a minute, this witness is unreliable, and I myself will go to the Court of Appeal? Because that's obviously Nick Johnson hasn't done that.
No. I mean, I've never done it. I don't know if the prosecution have ever had cause to do that. All I'm saying is that if what Mark MacDonald said is true, that, it seems to me, is very exceptional. I mean, for obvious reasons, you've gone through a 10-month trial. You've called this man as your main witness. And if it's true that he has changed his mind, that's pretty significant.
And behind the scenes then, obviously this doesn't normally happen in a press conference situation, I imagine. What's happening, Tim, behind closed doors now? What is Mr. MacDonald doing on behalf of Lucy Letby now in terms of the Court of Appeal, and how is that working for people who don't really understand how this happens?
Well, I have no idea what's going on in that sense. I have no idea whether he has made already an application under Criminal Procedure Rule 36.15. He seemed to indicate that he has. And then, therefore, the ball will be in the Court of Appeal, who will have to decide whether they would permit her to reopen the appeal. As I say, I am not aware of any case, certainly recently, in which this exceptional procedure has ever succeeded.
And Tim, how long, you say the ball is now in the Court of Appeal, if he has made an application under this section, how long then does it take, on the basis that Mr. MacDonald is trying to circumvent the CCRC because that's a time-consuming process and that's not fair to his client, who he says has faced an injustice? What is, I mean, you say it's never happened before, so it's hard to know, I suppose, but what might the time frame be?
Well, it's going to be months rather than weeks, I think, because the prosecution, stage one is you lodge the application with the Registrar of Criminal Appeals. The Registrar of Criminal Appeals, who is the sort of senior manager, senior lawyer who manages all aspects of the management of cases before the Court of Appeal. And so the registrar, she will determine how the case should be handled and no doubt would give directions, including for the prosecution to respond to this application, to the allegation that the Court of Appeal was misled into refusing the appeal last year by presenting Dewi Evans as a credible expert. And they would need, I would think, several weeks to respond to that. So I would think this case would not come back before the Court of Appeal for this exceptional application to be determined for several months.
But considerably quicker, obviously, than the CCRC,
Yeah.
which can take years.
It notoriously takes years. I mean, there have been all sorts of scandalous cases. Obviously, there was the Andrew Malkinson case, which revealed an outrageously lengthy delay in processing it. I think no doubt things have improved, no doubt in the light of that case and the review, their procedures have improved. But it would be, I would imagine, years. It wouldn't be months before the case would be considered.
And from a barrister's point of view, how exceptional was this press conference? It's not usual, is it, for a barrister to hold a press conference on behalf of a client's case?
No, it's very unusual. Barristers don't normally front up press conferences at this stage. And perhaps the other thing more generally to say is that, of course, the audience for this case now is the Court of Appeal, is potentially the Criminal Cases Review Committee. It isn't the general public. I mean, this is the one case that does not need more publicity. I think everyone is aware of this case, and many people have got strong views on it. I'm not sure that the CCRC and the Court of Appeal will really be interested in the fact there's been a press conference. They're only going to be interested in the strength of the application.
Well, actually, you mentioned that, and there was an article, I'm not sure whether, I think we might have sent it to you actually, Tim, from David James Smith, who previously had a role at the CCRC.
Yes, I did see that.
In The Independent a few weeks ago, which was very, very interesting, apart from anything else, and we're going to try and get him on.
Yeah, it was good. I agreed with everything. I read it. I agreed with his approach. It was obviously expressing similar, as I've expressed, a skepticism as to the likelihood of getting this case before the Court of Appeal under the 3615 exceptional circumstances route. But neither he nor I, or any of us, know quite how strong the argument is that this main prosecution expert has changed his mind. I mean, I can't emphasize enough that if it is true that the main prosecution witness has effectively gone rogue, is what the allegation is, as after a 10-month trial, has now said, oh, by the way, I was wrong. I mean, if that is what's happened, that is obviously very serious and has very serious implications for the safety, frankly, of all the convictions. Because even if it's only relating to some of them, he was being relied on to present a case of homicide. He was the crucial witness for the medical causation of death. And we know there was no other evidence from the defence to contradict it. He was cross-examined, he was challenged, and so on. But in the end, he was the main medical expert. One of the things that did strike me as very odd, at least, or surprising, was that Mark MacDonald, he was asked by a journalist about why no defence expert evidence was called at the trial. And his answer was, I don't know. I wasn't trial counsel. And then he was asked, well, what about contacting the defence lawyers? He said, I haven't been in touch with them and I don't know why. Now, I found that very, very surprising, because whenever I get involved in a case on appeal, not having done the trial, the first thing you want to do is to find out why the case was conducted in the way it was. And 9 times out of 10, the advice you're going to give to your client, if, for example, an issue is, well, why was no defence expert evidence called? The first thing you do is to advise the client that he or she is going to have to waive privilege and enable the trial lawyers to explain why they did what they did.
Yeah.
What was the reasoning behind that decision? And I'm sure it would have been a decision that would have been discussed with Miss Letby. She will have been part of that discussion. She'll have read all. I know they apparently got quite a few expert reports, and in the end decided not to call any of the experts and limited their defence to attacking the credibility of Dewi Evans. So I don't quite understand why Mr. MacDonald says he hasn't been in touch with the defence, has no idea why they did what they did. And he also said, I have no intention, you'll never hear me criticise what the defence did. Well, all I can say is that from my experience, the Court of Appeal will definitely want to know why the trial was conducted in the way it was, and in effect, what expert evidence they had, which they decided not to call.
Yeah, very interesting. Really interesting. Tim, Owen, Casey, thank you very, very much for joining us again. No doubt we'll get you on again at some point in the future. Thank you for all your expertise.
Yeah, thanks so much, Tim.
It's a pleasure. I'll see you again. Bye-bye.
So, just to pick up on a couple of things that Mark MacDonald had to say before Christmas, he's saying that Dr. Evans told the jury at the original trial that baby C died due to an injection of air down his feeding tube, effectively air being pumped into his tummy, which caused his diaphragm to splinter. But actually, during his cross-examination by Ben Myers, Casey, Dr. Evans conceded that the cause of death may also have been an air embolus or air injected into his bloodstream. Now, he was accused at the time by Mr. Myers of making up explanations on the hoof and changing his mind on his cause of death. The significance, if this is what Mr. MacDonald is referring to, is all this was actually played out during the trial and heard by the jury. It's not necessarily new. And as Tim said, the reliability of Dr. Evans's evidence was also considered by the trial judge and again by the Court of Appeal and dismissed. So if this is at the centre of Mr. MacDonald's point, the appeal judges might not necessarily agree that Dr. Evans has changed his mind. And we know also that he denies changing his evidence because of that statement he issued the day after the press conference. Now, similarly, there was a focus in the press conference on the death of baby O. Mr. MacDonald said new experts had now reviewed his medical notes and found that the serious liver injury that the trial heard had been caused by Lucy Letby was in fact caused by a doctor during the attempts to resuscitate him. Now, we know that a needle was inserted into baby O's abdomen to try and reduce swelling, but Mr. MacDonald is now saying that in fact that needle damaged the liver and could at least in part explain why he died. So again, this evidence was heard and challenged at length during the trial. So again, might not necessarily be considered to be new. And it's worth saying that as of yesterday, Mr. MacDonald hasn't made any new application to the Court of Appeal, but when he does, and if we have more on any of this, we'll of course bring it to you.
Yeah, before we finish, we also just wanted to mention something else that's happened, and that's this week in the House of Commons. And that was a speech by David Davis MP. Now, this happened at the end of Wednesday's parliamentary session. Now, David Davis said he'd become involved in Lucy Letby's case because after the trial, he started to be contacted by a number of different experts, doctors, statisticians, and others who he said were concerned about the safety of Lucy Letby's convictions. Now, he's spoken out about this before, but on Wednesday, he went a step further in Parliament and he called for her to have a retrial because he said he now believed her convictions were based on what he called bogus evidence. Now, obviously, he's entitled to his opinion, and any statement that he makes in Parliament is subject to parliamentary privilege. But we did just want to address one aspect of what he's been saying, because in fact, we don't think everything that he's been saying is necessarily correct.
Yeah, so one of the things he's been saying, Caroline, quite a few times, not just on Wednesday, but also on TV previously, is that the jury were misled by the prosecution graph, which showed that Lucy Letby was on duty every time a baby died or was harmed. Now, he said this graph was flawed because it didn't include other deaths that happened at the hospital over the same period. And he claimed that Lucy Letby was not on duty when those other deaths occurred. So, just to explain, because this is where it gets a little bit complicated, Lucy Letby was charged and convicted, as we know, of murdering 7 babies between June 2015 and June 2016. But in fact, there were 13 babies who died in the neonatal unit over that period. In other words, there were another 6 babies who died that weren't part of the case. Sir David has said Lucy Letby was not on duty for most of these deaths, when in fact we know that she was. And we know this because we've seen the full thematic review that Arian Powell carried out. This shows that Lucy Letby was on duty at the time, or shortly before, when 5 of those 6 other babies died. In other words, she was on duty for 12 out of the 13 deaths at the hospital that year. Now, I've managed to speak to Sir David about this since, and he told me he'd disagreed about the numbers and referred me to the expert statisticians, who he said had looked at them in detail, and he wouldn't comment any further.
Now, we should add there that those other deaths that we refer to there were never part of the case against her, and there is no evidence that we're aware of that those deaths were anything other than natural. But we did just want to point out what we felt was something that was incorrect in terms of the figures and that thematic review that Arian Powell carried out when she was working at the hospital at the time. So just to give a bit of clarity there. But that's all we've got for today. We'll be back next week for the final week of evidence before the inquiry breaks for a couple of months. In the meantime, you can catch up with any previous episodes or listen to the other trials in our series wherever you get your podcasts.
You can follow us at The Trial Pod on Instagram and on TikTok at Daily Mail Crime.
You can leave a comment on Spotify or send us a voice note on WhatsApp on 07796 657 512. Start your message with the word trial.
See you then.